United States District Court, Northern District of Illinois, Eastern Division. This was on the 15th. And this was the one I posted the other day that I was reluctant to read, but you guys want me to read it. So, motion to dismiss the indictment and pre-indictment delay. And the reason why I wanted to not read this is because it seems like they've been just denying all the defense, any and everything. And people was like, "We're still reading for the record." So I said, okay. Come now. Defendant Daryl McDavid by through his undersigned attorneys, Brindley and Glassman, and pursuant to Federal Rule Criminal Rules 12 and 48 and the Due Process Clause of the Fifth Amendment of the United States Constitution, respectfully moves this honorable court to dismiss the indictment due to the pre-indictment delay. In support, the following is offered. 1. Introduction. The government is stretched this case well beyond reasonable limits while attempting to bring an indictment against Mr. McDavid. It tries to criminalize events that alleged occurred decades in the past, but in the years since these events purportedly occurred, vital pieces of the evidence have been lost or destroyed. Key witnesses have died. Mr. McDavid's defense have died. Worse, the government knew about these very same allegations when they allegedly occurred 20 years ago and physically possessed some of the evidence that is now lost to time. Yet it repeatedly declined to bring any charges for years and waited until the 11th hour to bring a case after substantial pieces of evidence were already lost. As a result, Mr. McDavid is deprived of his constitutional right to prepare a complete defense and his right to a fair trial. As the law says, justice delayed is justice denied. The legal maxim in this full force here. The indictment must be dismissed because of inexcusable and unnecessary pre-indictment delay. 2. Legal standard. While the statute of limitations provide the primary safeguard against overly stale charges, it is not the only constitutional protection to a prompt trial and administration of justice. United States versus Merriam, case law. United States versus Henderson, case law. United States versus Sabbath, case law, explaining that the statute of limitations does not fully define defendant pre-indictment rights. Indeed, the due process clause forbids pre-indictment delays and requires dismissal of all indictments when the pre-indictment delay causes substantial prejudice to the defendant's right to a fair trial. Marion, United States versus Spears case law, stating that the due process clause assures that the government does not subject a defendant to an oppressive delay. In fact, the right to a prompt and fair justice even predates the Magna Carta and is deeply ingrained in our criminal justice system because it is a well-established fact that the trial conducted years after the alleged commission of the offense inevitably suffered from impaired fact-finding. Sabbath. The court must employ a two-step balancing test to determine if the pre-indictment delay violates Mr. McDavid's due process rights. See United States versus Sawa case law, United States versus McMutieri case law. First, the defendant must show that the prosecutorial delay caused actual and substantial prejudice to the defendant's right to a fair trial. Henderson. The defendant must show actual and substantial prejudice, mere speculation. McMutieri at 48 and 42. After this, the burden shifts to the government and come forth and provide reasons for delay. Sawa. The court then balanced the government reasons against the prejudice suffered by the defendant to determine if the delay violates due process. Henderson. And the government does not have to act intentionally or in bad faith for this court to find due process violation. If the prejudice to Mr. McDavid's right to a fair trial outweighs the government's reasons, it does not matter if the government acts intentionally, reckless, or even negligently. United States versus Williams, case law. Explaining that the government unintentional delay may still requires dismissing the indictment if the delay is so detrimental to the defendant's case as to be patently unfair. Sabbath at 1018. Explaining that the core holding of Sawa is that pre-indictment delay is determined by the balanced test, not a rigid set of fault. United States versus Lavasco. Noting that the government conceded that a prosecutorial delay incurs a reckless disregard of the circumstances known to the prosecution will violate due process. United States versus Raw, case law. Allowing pre-indictment delay based on negligence prosecutorial, Howell versus Beckel, case law, allowing the same. Finally, the defendant may establish a prejudice caused by the pre-indictment delay both before and during the trial. See federal criminal rule allowing pre-trial motions to dismiss for pre-indictment delay. Merriam, stating that events at trial may demonstrate actual prejudice and pre-indictment delay. For example, in the United States versus Gliss, the district court took pretrial motion to dismiss the pre-indictment delay under advisement and ultimately terminate the trial once the prejudice became apparent. In addition, Rule 48 allows the court to dismiss an indictment if an unnecessary delay occurs in presenting the case to the grand jury or bringing the defendant to trial. Federal Rule Criminal 48B. While the Rule 48 standard is not circumscribed by the Sixth Amendment right to a speedy trial, it is driven by the same general consideration. United States versus Ward. 3. Argument. The government delay in prosecuting this case is inexcusable. It has consistently stressed the twist its allegation to try to bring a case against Mr. McDavid. And particularly, the government has bent over backwards trying to allege a factual base for the obstruction of justice conspiracy and centerpiece of their indictment that is not barred by the statute of limitations. Still, even under the government's theory, it's only managed to obtain the indictment with a handful of months remaining on the clock. Footnotes. Mr. McDavid still contends in explaining in his previous motion that the charged conspiracy barred from the statute of limitations, but he will not rehash those arguments here. Nevertheless, the heart of the government case concerns allegations that occurred decades ago. At its core, Count 5 alleges a conspiracy to create false documents and records in a DFCS investigation occurring in 2000 and a Cook County grand jury occurred in 2002, over 20 years prior to the state of this current trial. Docket 93, page 10 and 11. The most recent false document and alleged crime created in 2007, over 15 years ago. Case law, Goggett versus United States, explaining that the prejudice presumed from the pretrial delay intensifies over time. And over the years, evidence of the government's possession has apparently been lost. Witnesses who have offered testimony supporting Mr. McDavid's defense have died. Witnesses who have testified undoubtedly will have faded memory of these long past events. See Barker versus Wingo, case law, explain that there is prejudice when witnesses can no longer accurately recall events of the distant past, and this loss of memory is not always reflected in the record because what has been forgotten can rarely be shown. As a result, Mr. McDavid has been stripped of using vital pieces of evidence and witnesses, leaving him inadequate, alternately meaning of preparing his case. This cannot and should not be the case. The Supreme Court has long held that the defendant is prejudiced by the excessive and unnecessary pre-indictment delay when he suffers the loss of evidence. Footnote, notably, 4 of the false documents and records were alleged made even before the underlying obstruction defense, 18 U.S.C. 1519, was even enacted. From death or appearance of witnesses obstructing documents or failure of memory, Merriam. This is precisely what McDavid suffered from here. Over time, the government has apparently lost an original version of Video 1, which is essential to Count 5. Mr. McDavid needs that actual video to point out things on it that were shown to him before the 2008 trial, things which shaped his knowledge and his beliefs regarding the 2008 trial and 2002 grand jury on which the obstruction of justice charges focuses. Furthermore, there were defense documents and evidence I'm sorry. There were defense documents and evidence held by Robert Kelly, attorney, from the prior state proceedings that have been destroyed in the years after his case ended. Once the 7-year mandate for keeping files and records passed, documents critical to Mr. McDavid's defense were destroyed. These were documents establishing a relationship to the attorneys of whom he relied on for his belief and knowledge of this case. These documents include documentation regarding the obtaining of videos that the government now tries to falsely blame Mr. McDavid. Not only this, but numerous witnesses have died in the years in between the events, even raised the charges to the trial in the case, United States versus Barkett. Case law, finding actual prejudice when multiple key witnesses died during a 4-year pre-indictment delay. One of the most critical witnesses who will undoubtedly been mentioned throughout the trial was Jack Palladino. An investigator, Palladino was presented at critical event in this case. He was presented for the obtaining of a videotape that the government now falsely claims was received by Mr. McDavid. Palladino could have established that Mr. McDavid received no tape, that he was not present when the tape was handed over. But because of the decades delay, Palladino had died before the case was brought, had even been brought or even remotely timely manner. He would have been alive and able to testify. Despite the government's claim in prior motions, the original version of the video, one, is essential to the obstruction conspiracy charge in count 5. As previously explained in the prior motion, the charged falsely documented and records were created in response to the original version of video 1 that the witnesses were shown in the 2002 grand jury. It is only original version that matters here. For the jury to determine whether the defendant truly believed whatever video they were allegedly shown had minors in them or not, which is critical in any evaluation, or whether they obstruct justice. They must be shown the same version of the video that witnesses and defendant could have viewed back in 2002. Only they fairly and adequately evaluate a reasonableness of the defendant belief about what that video contained. Likewise, the original videos Kelly defense team used in the prior state proceedings to create reports analyzing the video and suggesting that it would have been altered are not lost and destroyed. Those items on which Mr. McDavid based his knowledge and belief about the video recording at question in 2002 case is essential to his defense. But after Kelly's case ended in acquittal, the records were destroyed after the mandated 7-year retention period. Those documents, too, would support Mr. McDavid's defense and help prove that he did not act with the requisite intent. See Gliss. Affirming finding an actual prejudice based on lost documents and investigative files being scattered among many people and offices. However, there are laws due to time and delay that was by no means necessary. Footnotes. As the court is aware, Video 1 has been subject to one of Mr. McDavid's previous motions where he sought to compel discovery to establish the chain of custody of the event and ultimately sought to bar the video due to the lack of authentication. Mr. McDavid understands this court ruling on the motion, but still contends and rather further establish at trial, however, that the original version is the only version of Video 1 that can be shown at trial, and that the government still cannot properly authenticate whatever version they currently plan to show. Palladino defense investigators will have also offered testimony to reinforce that these documents shown impacted the jury determination of Mr. McDavid's intent. He was hired to investigate the alleged allegations against Kelly and was present in crucial events that will only hotly contest to this trial. For example, an essential component of the government's case involves an alleged contract to receive a tape by individual B. Palladino was allegedly act on as an agent for Kelly and Mr. McDavid. His testimony would have contradicted individual B, and government cooperator, and a large portion of the case would have hinged on what he said. See Sawa, affirming finding that the defendant suffered actual prejudice because he cannot recall the event of the offense after the pre-indictment delay. At the same time, the pre-indictment was entirely avoidable. The federal government was in actual possession of the original version of Video 1 when it first surfaced in early 2000s. Both Chicago Police Department FBI reports clearly states the FBI agent viewed and were sent the original VHS tapes that contains Video 1. See this, I guess, record from the FBI files and the Chicago Police Department files. And in fact, in 2008 trial, a state witness testified that the original VHS tapes was sent to the FBI agent George Skoluba to analyze. And when he sent them back to the state investigator and possibly initialized the tape, is confirmed the chain of custody. Trial transcript page 164-65. The testimony also suggests that Skoluda indicated in his report that he could not identify Kelly. Yet, now the government contends that they have no way to tell what video that was or if it even exists. Moreover, the indictment alleged that there was another agreement to retrieve a tape that involved individual C and individual D. The government was also aware of the allegations over a decade. Investigators interviewed individual D about the allegations back in the early 2000s when she made similar accusations to those alleged in the indictment. Despite possessing the tape and having known about the allegations for decades, the government declined to bring charges. Indeed, it declined to do so on multiple occasions. See the FBI files from October 3rd, 2005. Closing Kelly's investigation. May 31st, 2008, closing the case file on new accusations against Kelly. Instead, it did nothing while being fully aware of the allegations and possessing evidence for decades. As a result, they let substantial pieces of evidence get lost to time. Even according to the allegations, nothing has changed. There are the same allegations as they were before. But now Mr. McDavid has been deprived of significant evidence he needed to prepare his defense. The prejudice he suffered from due to his pre-indictment delay has deprived him of the right to a fair trial, and it outweighs whatever reason the government has for such an unnecessary and excessive delay. Sabbath. Dismissing the indictment due to pre-indictment delay because, despite of the prosecution knowledge about the circumstances surrounding the investigation, ill-prepared reports, elderly and sick key witnesses, a case agent who passed away, faded memories of the government's own investigative agent, and missed physical evidence, the government consciously delayed seeking the indictment for a mere 4 years. The indictment must be dismissed. 5. Conclusion. Wherefore, Defendant McDavid respectfully moves this honorable court to dismiss the indictment and enter any other equitable relief to deem just under the circumstances. Respectfully, Brentley and Glassman.